Welcome back to the No Stay Project, live from the Ford Fight compound in Mesa, Arizona. Don't know what happened there for a while, but it is episode 102 here of the big show. Coming to you live, of course, as we do every Wednesday from 4 to 5 Mountain Standard Time. And hopefully that is all the tech issues that we're going to have for today. Wow. I want to thank everyone for the continued support of the show. If you'd like to, especially Chris in California, who the next few shows are coming to you because of his support, and I do appreciate that. If you want to help support the show, it is definitely needed and appreciated. You can do that at markstevens.sells.com. That's S-E-L-Z, markstevens.sells.com, or you can just go to my website, markstevens.net. Where we have, the website goes pretty good. It don't have nearly the tech issues that the show seems to have. So, thank goodness for small things there. But you want to join me here on the big show, and I'll give this out, and it is in the description. If you want to call the show, it's 218-632-9399. 218-632-9399. The passcode is 2020. The passcode is 2020 with the pound sign, or the hashtag 2020 and a hashtag. That gets you into the queue to get onto the big show. So if you want to talk about anarchy, a voluntary society, a world without government, being that government is just a group of men and women forcing strangers to give them money, not exactly an ethical organization, more on the criminal side, of course, or government abuse, which is what I'm going to talk about now before we start getting to some calls, or defending yourself in court. Effectively defending yourself in court. Doesn't mean that I'm offering some kind of magic bullet here, right? You just say this and it all goes away. That's not what it's about. This is work. And you're going against people who are fairly hardened criminals. Being that, like I go through when government indicted, which is available at markstevens.net, there is definitely psychological implication and things that happen psychologically to change people's behavior when they are part of a violent hierarchy and they have no responsibility whatsoever to the victims, the people that they're actually abusing. The Milgram experiment is a good example of that, where people will override, that conditioning will override their empathy, their feelings like, I don't want to do this, it's going to hurt somebody. But they'll do it anyway because they're not being told by an authority figure, so-called, and they're not responsible because the guy in the white coat's responsible. So no matter how hard you beat them or no matter how hard you hurt them, or even kill them, you're not personally liable. And that's a very liberating thing if you're a psychopath or have those kind of tendencies. If you're the criminal persuasion, not having a responsibility and being put in a position where your victims cannot hold you to any kind of accountability, boy, that's what they call being drunk on power. Completely irresponsible behavior. You can do whatever you want. Which brings me to the point I want to discuss here on the show before we start getting the calls. This is a story that you've heard 1,000 times in just the last few years. Every single week or so, there are stories like this. This is what I was talking about with the Lolita Express the last couple of shows regarding Jeffrey Epstein and Clinton, Trump, and Alexander Acosta, who was the U.S. attorney who signed off on Epstein's sweetheart of a deal. Not just a sweetheart deal for Jerry Epstein, but for his as of now undisclosed co-conspirators, which I'm sure Trump is on the list, as well as Bill Clinton and that lawyer. Alan Dershowitz, Prince Andrew is on that list. Well, he's definitely on the list where he's traveled on the Lolita Express. He's gone to the Jeffrey Epstein's private island where they were trafficking these children, teenage girls, as young as 13, 14 years old. And why we shouldn't have that is because these criminals are given you know, they're given a gun and a badge. They're given they're given authority, and they're given orders. They go out and they do and they're completely unaccountable to their victims. So we hear these stories all the time. While we may not get all the time the stories regarding how government and billionaires are protected and don't, they don't get held accountable for child molestation, trafficking, we do have a constant flow of stories like this regarding police officers who shoot people, at least, especially those who are not pasty, white, rich Europeans. See, that's the thing. The rich part is the big part here. That's where the privilege is. And if you don't think that there's a rich privilege, holy crap, I don't know where you've been living. Just do a search on affluenza, where judges don't want to put billionaires or multimillionaires. They don't want to put them in jail because they won't handle prison well. So that's a mitigating circumstance. If you have the money, if you don't have the money, cops can kill you. No repercussions. Again, I'll go to Slager, and I think it was North Carolina or South Carolina. Shot a man in the back on video. And there's pictures of him falsifying the record to make it look like he feared for his life. All on video. This is one of those cases where you have the actual evidence. You have direct evidence that he's lying. Lying. Nothing. They couldn't convict him. So here, Stefan Clark in California, and they're saying that there's no charges. The county attorney said there was no charges. They did not violate policy. They didn't violate their training. And even the AG came out and said, no, they didn't. The facts show that they didn't violate policy. They killed a guy. They killed him. Negligence? Can we even get them on negligence? No, they're cops. They're part of a violent hierarchy. They have no responsibility when they kill people. They can kill people with impunity as long as they are not rich. If they're rich, if they kill a rich person, then maybe they'll do something about it. But typically, especially if they're not of the white European persuasion, cops can do whatever the hell they want to the poor. They can do literally anything they want, and they will get away with it. And this is another example. They said that they thought that he had a gun. It was a cell phone. They thought it went off. I don't know. Maybe because his cell phone gun app was on, he turned the volume all the way down. Because when he shot his cell phone gun, there was no report of a gun. They didn't report that they heard a gunshot. Just what looked like a gun. And again, this goes back to my military training. Yes, I was in the military, and I've done war games. I know I was never in actual combat, but I'm familiar with the training. And I've played point man before, more than my share of times, I'll tell you. And when you hear a gunshot or you hear the trees start speaking Vietnamese, your first response is not to open fire. I was always taught your first response is to get down so that you don't get hit. Because obviously if somebody's shooting and you're standing up, you're a pretty good target. So do the cops drop to the ground, assess the situation, and then fire back? No, there's no report of that. They just open fire. That's what they do to us. They open fire. And just like what happened here in Mesa, in the hotel, they got the guy on the ground, and they're screaming they're going to light him up. He's screaming. He's begging for his life. And they're giving him conflicting commands. What do? They light him up. Again, got away with it. Murder on video. Got away with it. Attorney General Javier Becerra announced the results of a nearly year-long investigation after telling Clark's mother privately he acknowledged that it was not what Clark's family wanted. I guess that relieves you of, okay. I guess what you're doing isn't wrong anymore. But said the evidence showed the officers had reason to believe their lives were in danger, though investigators found only a cell phone. There is a lot of hurt in this community today, and certainly in the home of the Clark family, Becerra said. Our investigation can't change what has happened, but we can make every effort to deliver a fair, thorough, and impartial review, which we promise this community. Yeah, after a year. You think the cops spent nearly a year in jail during the investigation like we, the plebes, would? Yeah, the private prison system. Yeah, for profit. There's your capitalism at work for you. Yeah, last bastion of true effing capitalism. Private prison system. Actually, not pure capitalism because it relies on socialism. But I figured I'd get ahead of the curve for the YouTube comments. So there were demonstrations. Clark 22 was suspected of vandalism when he was shot 7 times. On March 18, 2018, his killing prompted protests in California's capital city and across the U.S. Yeah, because it was another example of a black man without any weapon that the cops feared for their life, allegedly, and shot him 7 times. Who knows how many times he actually shot? Now, I'm not advocating that anybody go and do this. I'm making an argument to demonstrate how ridiculous this really is. I want you to imagine what would happen if one of the plebes, let's say for, just somebody who was carrying a gun for self-protection and police officers advanced on him rather aggressively, and they had their cell phone out. And this individual unholstered his gun and pumped 7 rounds into the cop. Now, if he survived the initial investigation, does anybody think that he could say, I reasonably feared for my life, I know that it was just a cell phone, I didn't know that at the time, they're police, they have guns, they typically have guns, he was advancing on me, I felt in fear for my life, so I unloaded right into him. And then I reloaded, and I loaded, and I emptied another clip into him, because I feared for my life. Does anybody think for a second the cops and the prosecutors would buy that from one of us? I was afraid of I feared for my life because somebody had a cell phone? Maybe some of the alt-right would be thinking, was it a black cop? Because then you got a point. I don't think that matters. You got a cop who seems to be advancing on somebody with a cell phone in their hand. I thought it was a gun. I feared for my life. Just like Amber Geiger. She goes to the wrong apartment. She feared for her life. She went to the wrong apartment. She didn't recognize her own apartment. Oh, these black people, he took he took all my stuff out of the apartment, even put up pictures of himself. So I feared for my life. Sprinkle a little crack on him before we're done here. There's no way in the world that any prosecutor would buy that from us. If we killed a cop, if we killed a congressman, this congressman, he came at me and it looked like he had a gun in his hand. Can you imagine gunning down a congressman? Oh, imagine gunning down a prosecutor, gunning down a county attorney or an attorney general, just gunning him down and saying, whoa, I know he ultimately had a cell phone, but I thought he had a gun. I legitimately feared for my life. Because that's exactly what these cops are getting away with. Yeah, but Mark, he was a suspect in the vandalism. He had a cell phone. What? Honestly, tell me somebody who in a combat situation where you know that you stand the chance that you're in a hostile environment, and tell me that the thing that you do is stand in the open and open fire. Especially if you're on patrol at night. Oh yeah, let's give away our position. They're just shooting because they hear us at this point. Oh, let me shoot and then make it and then confirm exactly where the hell I am so they can start shooting towards the flash. Why do we talk about anarchy? Why on a show about anarchy are we talking about such government abuse? Because this is the platform for these people to get away with wanton murder. Even if you don't charge them with murder, you'd think that even negligence. There's somebody that went in and asked some questions, spent the weekend in jail on a traffic case, a traffic complaint, spent 2 days in jail because he asked questions to the judge. Even as he's being jerked away from the defendant's table and being put into custody, the cop is yelling at him that he's arguing with the judge. Now, let's assume, just for sake of argument, arguing with the judge is such a heinous offense, it warrants time in jail. Let's use that yardstick for just a moment. If that is the case, isn't shooting somebody and killing them, even in negligence, doesn't that warrant any jail time? If you can go to jail for asking a judge a question? Don't tell me we don't have 2 sets of rules. Don't tell me there's not an oligarchy here and that the king's men don't have a different set of rules. If you and I can go to jail for 90 days for literally asking a question, even if it's not a relevant question, why don't these cops get any time at all, any time, even for damn negligence? Negligence. If you and I shoot a gun up in the air, we can go to jail. They can kill somebody. Nothing. Again, take murder off the table. At least go for gross negligence. You killed somebody because he had a cell phone. So what is that so the crime was actually done by the victim having a cell phone while black. Absolutely disgusting. So I would love to see what the argument is there, that they shouldn't even be charged with negligence. Not even for negligence. Because for the life of me, I cannot accept that someone trained to use a gun and going into dangerous situations unholsters and just opens fire without getting down first. Is it me? Is it that I'm trying to take military training and trying to take the same kind of tactic and basic instinct for self-defense and self-preservation? Am I putting that into a situation where it doesn't belong? That's perfectly reasonable that if you think someone is shooting at you, just stand there and open fire back? What is this? All this gunfight at the OK Corral? You just stand there? I can't accept that. If I'm armed and I think someone has a gun and may open fire at me, my first thought is to get my ass down or get behind something. Protect it. If the cops are so, I'm the one going home tonight, it's the most important that I go home. Then if you think someone has a gun, if you think they're going to be firing at you, get down or get behind cover. This open fire and emptying your clip at the slightest provocation. A cell phone. I can't remember Diallo, the case in New York. They ordered a black man to identify himself. He goes to get his wallet and he's gunned down. What is someone supposed to do when they're poor, especially if they're black, when the police arrive? Are they just supposed to instinctively drop to the ground with their hands? But even then, they shot the guy right here in Mesa, right downtown. I guess when you've got these cops, and yeah, a lot of them are on steroids, and steroid rage is very real. Increased testosterone, and then you give them a gun and no responsibility. Yeah. Oh, I may not have a PhD in psychology, but I think you got yourself a problem there. Oh, bad news. Bad news. But enough of that. But again, I just want for any critics, the number is 218-632-9399, 218-632-9399. The passcode is 2020. If you've got an argument, a legitimate argument, that for why it is okay for cops to routinely stand there when they think they're being fired on and to just open fire, I'd like to hear it. And if you think that I'm taking my military background and common sense and injecting it into a situation where it has no business, that's apples and oranges, I'd like to hear the argument for that. Because I think if the cops want to go home that day, you don't stand there and open fire, because you don't know he's the only one. How do you know he's the only guy? How do you know he's the only one gunning for you cops? So for cops out there, just do yourself a favor. If you think someone is that much of a threat, that your life is in imminent danger, don't stand there. Get yourself to cover. That's not being a coward. No, the coward is the guy, Peterson, in Florida, who refused to go in when there was actually somebody with a gun. Yeah, see there, the cops, not so much. If there were reports that somebody with a cell phone was attacking the school, maybe Peterson would have went in. Oh, Captain Bonespur would have went in even without a gun. It's just absolutely, we shouldn't have, and it's immoral to have a violent ruling class, because again, we're going to keep getting things like this where people like me and people like you, the plebes, we the little people, will continue getting killed at 1,000 times the rate of other domestic terrorists from cops, because of the violent hierarchy that is there to protect the violent hierarchy. Not us. There is no duty to protect you and me anyway, so anyhow. Let's get to the area code 815. You're live on the No State Project. What's your name? Where you calling from today?
How's it going, Mark? This is Blake Atlas.
Blake,
okay.
I'm sorry, where are you calling from?
I'm calling from the suburbs of Chicago, Joliet specific.
Oh, Joliet. Home, wasn't it the home of Al Capone?
The Blues Brothers. Yes, Al Capone. Yeah, I mean he had a good influence around here. I'm not sure if this was his home though, but maybe.
Is there a prison in Joliet?
Absolutely.
Okay, that's what I'm thinking about. I'm sorry. Yeah, Al Capone. Yeah, but yeah, I'm thinking of Joliet because of the prison. Okay, so what can I do for you today, Blake?
Yeah. Well, today I had a motions hearing and a bench trial. So I just wanted to kind of ask a couple we'll take you through the whole scenario real quick. How much time are you working with here? I know you got probably a couple other callers.
We're doing decent on time. We're only halfway through the show, so.
All right, nice. Well, anyway, so yeah, first of all, so I had 3 traffic citations, or alleged traffic citations. One was for speeding in a school zone. They said I was doing 42 miles an hour. Another one was for failure to have insurance documentation, and then the third was failure to basically have a driver's license on you, on your person. So anyway, so this was my maybe 3rd time going in today. Three strikes and you're out. And so the prior hearing was for their first trial of arraignment, but the judge partially granted my Brady motion. So the case was continued for about a little over 2 months. So from January 2nd was that arraignment, and then the partial granting of the discovery, and then today was the next hearing, which was originally supposed to be bench trial. The judge had entered her plea on behalf of the prosecution, not guilty.
Well,
I submitted a motion.
That's pretty big of them.
Vacate that. Yeah, in terms of partially granting the Brady.
Well, of being a douche and pleading not guilty on your behalf. What of the Brady was granted and what was denied?
Well, basically, he granted any documentation, audio, video reports that the prosecution might rely on. However, the partial part is he's basically sidestepped the prosecution's, at least prima facie burden of some sort of evidence that they rely on to prove that just because I'm physically in Illinois, the laws and Constitution apply. Which heretofore I still haven't seen any of that evidence. And the prosecution and the judge, and oftentimes on behalf of the prosecution, offered, their opinions.
Well, sure. Okay.
Those various different ethics requirements, this type of case, in even some criminal cases, the prosecution isn't technically required to, object it away and, no problem, preserve the record or set the record.
So when you have on the Brady that you want the name of the witness with personal firsthand knowledge that the Constitution and laws apply because you're physically in Illinois, the judge just blew that off, and the prosecution didn't even they probably didn't even address that part, right?
They did actually. Well, I did. Because at the end of the motions hearing where he denied my so today I had four motions: a motion to show cause for failure to produce, a motion to vacate the plea, a motion to dismiss based on a failure to of oath of office and bond on file, and then I think the other one was prosecutorial misconduct. So at the end, so he denied all those. I objected as best I could. At the end of the motions hearing, I asked if the prosecution had any evidence of a witness with firsthand personal knowledge of the things that they might testify to if there were to be a trial. And the judge, offered his opinion in terms of, oh yeah, I'm sure at trial he tried to make it a trial issue, and I objected. Kind of ambiguously. I stay on the record. Objection. I'm not necessarily sure of the exact reasoning, but I would like the record to reflect my objection.
Okay.
So
Wait, Balake. For the, I can't believe I actually missed that, so I'm glad someone pointed that out. I do want to jump in here because I would, for those who are new, I want to go over the objection that I think is appropriate to be made there. And the objection there would be, well, objection, doesn't pretrial discovery require him to provide it now, not at trial? Isn't this a discoverable issue?
Yes. And so what's good about having three separate hearings or just three separate, instances of going in is I've objected to actually that at the first hearing. I asked, the objection doesn't the prosecution have at least a prima facie burden, to provide evidence before trial? And then I even object, and I said, so are you telling me that, the prosecution can surprise me at trial with evidence? And to which he was silent.
Another thing, too, though, here, Balake, is that we want to object and say, has the prosecution at least met a prima facie burden on jurisdiction to this point? Why, because that's there has to be jurisdiction. There has to be evidence of jurisdiction from the prosecution, whether it's civil or criminal, before you get to a hearing, or you're required to, in a civil proceeding, file an affirmative answer. There has to be evidence of jurisdiction, personal and subject matter, before the court can now start ordering people to appear at pretrial, at arraignment and pretrial. Again, the reason why I bring this out, why it's so important, and why it's not it's not frivolous to raise this, because they do it all the time when we sue them. There's no way in the world a judge is going to look at another judge or their lawyer when we sue them, and they raise the issue of a lack of jurisdiction because of absolute judicial immunity. They're not going to say that that's a trial issue. Oh, sir, Mister, you tell your my fellow judge that you're representing, you tell him for me, okay, he doesn't get to argue lack of jurisdiction at pretrial. I mean, come on. That's not the way the system works, and the critics know. But they don't want to admit that when we do it, it's not frivolous. So I don't want anyone thinking that when we raise the issue of jurisdiction and they say that's for trial, no. Absolutely not. And I challenge anyone. If you don't believe that that's true, especially if you generally follow the work of you're an anarchist, if you don't believe that that's actually true, and I implore, in fact, I've wanted someone to do this, especially in New Hampshire where we had the goods on them. File against them. File against a prosecutor or a judge with the express intent of trying to get them to, when they file the motion to dismiss, and then you go in and argue, nope, we've got you on the record, because like the one judge in New Hampshire, Burke, we've got you on video saying jurisdiction's a trial issue. You don't dare get the chance. You cannot possibly argue a lack of jurisdiction before trial because you said this. Because if that's where I think we got him, because if they say, well, that's not true. Yes, I know it's not true. That's why we're suing this dishonest guy. We know he committed fraud. We know that. We know he's a crook. And that's how I think we can catch him on. Anyway, I'm sorry to derail things, but I thought at least the first part was we needed to discuss.
Yeah, most definitely. No, that's good stuff. But okay. Yeah, so I mean, well, so now we're at the...
You're at trial, and so do you object again to his lack of a witness or personal knowledge that the laws apply and you violated them? Did you object to him being put on the witness stand?
Not specifically, but at a certain point, I did generally renew all my objections. Because at this point, I mean, I've had probably close to 100 objections, I bet you. Probably not quite that many, but I'd say at least 50, objections throughout,
Well, we got it. What you have to keep in mind, Balake, and also everyone listening, when they go to put that cop on the stand, you can't say it, emphasize this enough. You have to object that there's no proof from the prosecutor that the witness has personal knowledge of the matters they're testifying to, specifically that the laws apply and you violated them. There's not a single shred of evidence that no proof at all that they have personal knowledge.
Right. Yeah, definitely. Yeah, that's something that I definitely overlooked, and I plan to do. But
So when the cop is on the stand and he's being questioned, did you make any objections during the direct examination?
Yeah, I objected. He was in his initial line of questioning. He was just leading. He's like, so but their questions like, where do you work at so and so?
The judge.
So I said leading, whatever. But
but those are okay. Those initial setup questions like that, which aren't going to the merits of the case, those initial leading questions are okay. It's after that when they're trying to establish facts, and proof for the actual offense, then leading questions aren't okay. But those initial ones are okay.
Yeah, what makes it really comical though is in the trial before me of someone else, the defendant, alleged defendant, didn't have an attorney, but the attorney for the state or whoever was asking his witness leading questions, and the judge actually prosecuted from the bench and objected to the prosecutor. It's pretty funny.
Well, I
So then,
wouldn't. Well, let me jump in. I don't think that that's necessarily prosecuting from the bench. I would just say that's the judge whose job, part of his job, is to ensure due process. So I've even seen where lawyers didn't catch it, and a judge said, "Excuse me, counsel." That's leading, and so some judges will do that, and I think that they should, which is good. So let's jump ahead before we're out of time. What happened on the cross-examination?
So this was something that I wasn't expecting. So earlier on in the motions hearing, the prosecutor moved the court for judicial notice that the laws and constitutions and statutes apply generally. They just apply. It's basically what his judicial notice was, and the judge sustained that.
Did you object?
And, definitely.
Okay, and according to the rules, there's supposed to be at least a short hearing on the propriety of taking judicial notice, and so your objection should have included objection. That's not an adjudicative fact. That's literally an argument of the prosecution. Did your objection sound like that?
It was not that specific.
Okay, let me just take a moment here. We'll get back to the cross in just a second. Guys, you got to keep in mind, judicial notice is for adjudicative facts. And if you're in California where they can take judicial notice of the law, it's only what the laws say, not whether they're applicable or not, because that's an argument from the prosecution, okay? That is a legal argument. It is not an adjudicative fact, and it's not what the laws say. So we need to make the objection that it is not an adjudicative fact. It's literally a prosecution allegation or claim, and it's not the proper subject for judicial notice. Okay, so we're in the cross-examination. How did that go?
Right. So I had my initial question was actually I asked him just generally. They had mentioned the radar gun, and they had mentioned when he tested it. So I asked this for kind of more definitive, like when. He said, yeah, I tested it before and I tested it after, but they never said when. So that was my first initial question. But then my second question was, did you determine on your own, that just because I was physically in Illinois, that the laws and constitutions apply to me? And he said, actually, the prosecution objected and said, and cited his judicial notice, and then the judge abstained or sustained, I should say. And I did it and I asked the question literally 3 times.
That is remarkable because you are the only one I can remember in recent. I don't remember anyone saying that there was an objection to that first question that the one you just asked. They always let them answer that. And even though they've taken judicial, even if we say that the taking to judicial was okay, that doesn't mean that the witness can't answer what happened at the stop. It is. Now that is some serious evidence of collusion between the prosecutor and the judge, because there's no valid reason to not allow that question. Again, it doesn't matter if he took judicial notice, and we're excusing that. It's something that happened at the stop that led to the ticket being written, and it is proper for cross-examination. So, okay. So let's just finish with the cross-examination. So what was the next question that you got to ask?
Then I asked if he had any facts that he relied on to make his determination.
Okay.
And he said yes.
Oh, good.
And I asked him what facts did you rely on to support your allegation or your assumption that because I was physically in Illinois, that the laws and Constitution applied, to which the prosecution objected, and citing his judicial notice, the judge sustained.
Okay, classic douche move.
Right. But then the judge, actually, I objected to that, and the judge.
Yeah. Did you object? Did you object and say it goes to his prior statement? He just testified. This goes to what happened and what he determined at the stop.
Right. The prosecutor made some argument, and I objected. It calls for speculation, and the judge sustained my objection and said that, well, really, the facts. Well, he sustained the prosecutor judicial notice, but he said, but I'll allow the officer to ask what facts as it relates to, what he observed or saw.
Okay, and what did the cop say?
And the officer said that he saw my vehicle speeding. And I asked, is that the only thing that you relied on? Only fact that you relied on? And he said yes.
Okay, did you follow up with asking him to explain how was my speed? So my speeding proved that the laws applied?
Actually, no, at that point, that was kind of my last question.
You gotta, so if they cut the cross-examination off, you still have enough proof there for a denial of effective cross, I think. But I would have followed up with having him explain, so just so I understand, you saw me speeding and that means, and you and that to you meant that the laws apply, and I violated them. Okay, and then I would have continued, but I'd like to hear more of this, and I will be live on the Saturday show, so it's just that we're almost out of time already, and I want to get to at least one other call.
Yeah, no worries.
But I will say, contact me off air. I can get you the notice of appeal and a petition for post-conviction relief, because I think we already know that you were convicted, right?
Oh, so conditional discharge is what he ruled.
A conditional discharge.
4 months.
Well, hey, that counts for something. Listen, I got to let you go, but give me a call on the Saturday show. So with 2 to 5 Mountain Standard Time, and so give me a call and we can finish up with what happened in court. Okay.
Yep, that sounds good.
All right, appreciate the call, Balake in Chicago. And not too much time left here, but I've got Sebastian in Los Angeles.
Hey, Mark, how are you?
I'm doing well. I'm glad to hear that he got a conditional judgment there. So it's kind of, so that it's not as bad as, it's not like a big fine and whatnot. So at least I think the judge could, see that, this cop really didn't know what he was talking about. And I'm just assuming that. I'm glad that the judge, finally, we can report, one judge has said, yeah, he can answer what facts led to his decision. Yeah! Oh, yeah, of course they can. But I got all these people saying, oh, no, calls for a legal conclusion. Anyway, I'm sorry. So you have good news for us?
Well, I'm in the middle of an appeal for, I got a red light traffic ticket, and I was ruled guilty. And so I put in the appeals paperwork. I'm about to have to write a brief at some point.
Okay. You should be able to get, I do have an informal brief that you can use that you typically, in traffic cases, going from a municipal court to the Superior Court, you don't have to do a formal brief. So contact me off air for that.
Okay. And there was something that you mentioned on previous shows where I think it might be applicable to an argument I could use, where I like it how you say something like, you ask the judge, do you understand the difference between stare decisis and res judicata? And what I'm thinking you mean is that, each case is fact specific. So if they start trying to use precedent to say that, I can't challenge jurisdiction because somebody else lost on that thing, I'd say, well, my case is fact specific, and, you have to show how it applies to my situation.
I don't know if I've recommended. Maybe I have. Depends on the heat of the moment kind of thing. But I think saying to a judge, do you know the difference between res judicata and stare decisis is going to get you a contempt charge. So I think I would soften it quite a bit, and I would say, are you trying to use a court opinion to settle an issue of fact?
Okay.
If I'm talking to a prosecutor or somebody outside of court where they don't have the power of contempt, I'll go right ahead and I'll say that. Or are you confusing res judicata? And I actually put that sometimes in documents. I'll say the prosecution is deliberately conflating stare decisis with res judicata.
And can you explain, I've read something online to try and understand what the difference is, but can you, in layman's terms, articulate that?
Stare decisis has to be that the decision's already been made. It's okay, on an issue of law, a pure issue of law, like what the law actually means and requires. So, for example, stare decisis would be what do the courts say prosecutorial misconduct is? And so the courts have said, like in the Shaw case versus the Robertus, I think it is. It'll be in the video later. Arguing without evidence is prosecutorial misconduct. So down the line, we don't have to keep rehashing what prosecutorial misconduct is because the courts have already determined that this is what it is. Now, whether you are guilty of it, that's different. So that would be like, let's say, stare in res judicata, literally from the Latin is the thing has been decided. That is where the facts, the legal issues and the facts have already been through trial and have been decided. So the pretrial's been done, the pretrial motions, all that's been done. You've gone to trial, you had a fair trial, and the facts that were determined to be true through direct examination and cross-examination are not up for dispute. End of discussion, done. So that's the difference. That particular set of facts cannot be revisited unless you can show that there was an error in the admission of the facts. But generally, stare decisis, or res judicata is, these facts have already been determined, it's already been litigated, A, B, C, and D, that's the way it is.
Okay. I'm just trying to think of what kind of stuff I can use. I can definitely use the Robertus thing in my brief to say that they offered no evidence of jurisdiction, and that's where they went wrong. Because last time I went through this, I did an appeal and I had a 3-judge panel. And let me just read their decision as far as my challenge to jurisdiction. They said, defendant fails to offer any meaningful analysis of the law in support of his various contentions detailed above. For this reason alone, they cannot constitute grounds for reversal of judgment. See People versus Murray. An appellate court is not required on its own motion to develop arguments for an appellant. People versus Albarca. And defendant's failure to furnish legal argument with citation to authorities on the points made operates as a waiver on appeal. People versus Stanley.
Without having read the brief, I can only speculate. Now, I know from personal experience that we've gotten things like that, and it was in the brief. They just ignored it, and it's just like they ignored the facts. We had an appellate panel in Northern California in the federal court ignore a CD that was part of the record. They just said it wasn't there. I've had, in the Edwards case in Wyoming, where not a single argument that I raised was actually discussed. And they dismissed it based off of somebody else's argument. So, I don't know. Here, did you have a legal argument? I mean, we got to be real brief. What was all right. I'm going to venture a guess here that you did have a legal argument supporting your position that the prosecution lacked jurisdiction.
Yeah, I think that's probably where I went wrong, because I think in the thing it actually says in arguing at trial court that the trial court lacked jurisdiction over him, defendant offers following arguments. So I probably, instead of saying they lacked evidence, I probably said the court lacks jurisdiction and used stuff from your motion to dismiss. And that's probably where I went wrong.
You still had a legal argument, though. And so when we get there, typically what you want to do on appeal is quote the prosecutor. So sometimes, like Tiffany Castillo, for example, the legal argument is the prosecution bears the burden of proof through every step of the process, including jurisdiction. And, okay, they have the burden of proof. I personally don't think I need a legal citation to show that that's true. That's my argument, and it is a legal argument. They bear the burden of proof. The fact that I don't cite a court case, I think, is meaningless and not relevant because it's such an ingrained, it's not open to reasonable dispute. And then we can quote them.
Yeah, it's a maxim.
Yeah, it's a maxim. Yeah, we know that that's true. It's just like, I don't have to quote the Fifth Amendment to say that, or even quote I don't have to quote the Fifth Amendment about due process or even the 14th Amendment about due process. I can just say it was a due process violation and I was denied a fair trial. I don't have to go to the Fifth Amendment and say that and use that as a citation that I have a right to cross-examine. You put it in there just to be sure, but you're still making a valid legal argument even if you don't have 15 citations or even one citation. You have a right to cross-examination. That's a legal argument. Whether you put the Fifth Amendment or the equivalent of the state, I don't think changes the validity of that. So here they may have just been splitting a hair, but I like to be able to quote the prosecutor directly. So just like with Tiffany Castillo, we can use her words in the appeal. She said she didn't have the evidence and that she wasn't required to have the evidence. And those are the facts to back up our argument that they don't have evidence to prove jurisdiction because they weren't even arguing they had to prove it.
Yeah, I had a prosecutor, and I had her on the ropes, and she just pulled a douche move. I was like, what evidence do you have? And she said, well, it's the code. And I said, it's a circular argument. And I had her. And then she's like, Judge, I moved to go to direct examination. He's like, approved. And then they went straight to the cop. I was like, I object, and then they went on.
Well, okay, we don't want to in court say that's a circular argument. We don't necessarily want to say that when we're outside of court because we don't want to make affirmative statements. If you have to use the phrase circular argument, you can ask them, isn't that a circular argument to say that the code applies because the code says so? But you could ask, well, look, and again, I'm happy to plead guilty and avoid all this here, everybody. Is it really your position that the code applies because it says so? Really? And what particular statute that you have actually says that?
Yeah.
I'm bewildered, there may be a court citation that may say something like that, but a statute that says this code applies because it says so, I don't think they've ever written something like that. So that's a better way to address that particular issue. So when they say the code, like I've done with the call to shames, so your position is that the code is evidence proving the Constitution applies. Now, that's a great leading question. Because they're going to either say yes or no if they're going to address it. And 99% of the time, they will say, no, it's backwards. The code is not evidence of the Constitution. Great. First base. So again, what evidence do you plan to bring today? And who is your witness with personal knowledge of that the Constitution applies just because I'm physically in California? You can't say the code. The code, we now have an admission the code is not evidence. So, but get me off air, markstevens@mail.com, or Frank Rizzo 3 on Skype, and I can get you a copy of the informal appeal brief for California. And a lot of the legal arguments are already in there. You just have to tailor it to your set of facts.
Oh, great. Thanks.
Yeah, no problem. It's these people, their job is to keep you off point so they can rake you over the coals and they can convict you as quickly as possible. And so when you make affirmative statements like that, you take the burden off the prosecutor and now you have to prove it. So I think you're absolutely correct that it's a circular argument. I think it's a frivolous argument to say that the code is evidence of itself applying. But we don't get anywhere by actually using that phrase in court. So we want to ask a good leading question instead. So is it, and listen to the call of Shane's for those who are new to the show, because I actually say this to prosecutors and I say this to tax agents, and I said it a lot of times, and they'll reverse themselves, and now they're stuck. And that's why, Sebastian, I have a tax agent from Sacramento, there in California, admitting that the basis of the FTB's, the Franchise Tax Board's assessment, was an assumption, because he initially said the Revenue and Taxation Code was proof that the Constitution applied, and then he realized and agreed that that was backwards. So then when I went and hit him again with that question, so what proof do you have that the Constitution applies? And he knew he couldn't say the code. The well is dry at that point. The only tool he has is the code. It's the only thing he has to beat you over the head with. And when he doesn't have the code, he admitted it was an assumption. So, which is exactly.
Are you going to Culver City for your tax thing? Is that open to the public?
Actually, it's going to be in Los Angeles, and it got postponed to May. And so,
okay.
I think it's May 21st. And it'll be Los Angeles. It's not Culver City. I know that for sure. If I am able to make that, I will let everybody know. And so it is open to the public. So yeah, if people want to watch that, that would be great. I'll let everyone know on the show if I'm able to make that. And that'd be great. Yeah, so if I can meet up with you there, that would be cool.
Great. Let me know.
I will. I appreciate that. And contact me off air. I'll get you the informal brief.
All right. Thanks for your great work, Mark.
Hey, appreciate it. My name is Mark Stevens. That's all the calls that we'll be able to take today. But hey, I think we did. I think that we did pretty good for the show. I'm glad to hear that Balake. It sounded. I tell you, the conditional, after all he went through. I know I'm speculating. It sounds like he did a pretty good job. Yeah, there were things he could have done better. We can all, armchair quarterback there. But wow, that is the first judge in the United States that allowed and overruled that objection, that a call for a legal conclusion. And wow. It wasn't a responsive answer. I mean, and he needed to follow that up better, because obviously seeing me speeding, how does that prove a written instrument from 1879 applies? How is that evidence? How does that prove that? How does that support his claim? Of course, it doesn't. But wow, stranger things have happened. And I want to point out, it's an Epiphone Les Paul. We'll get this bad boy up there. Love this guitar. I'm not going to pick the amp up, but someone mentioned I should get the Les Paul. It's an Epiphone Les Paul. It plays, it plays just like one. I don't have a Marshall, but boy, I got a real nice Fender here. This thing. One day I'll plug in and play. But I appreciate the calls today. I'm glad that Balake did get a conditional decision. That's pretty good. That's basically, I take it as we couldn't prove you did it, so there you go. It's just like when I, in Mesa, was able to establish, and the judge agreed that the ticket wasn't evidence of jurisdiction, and yet it was the only thing they had for jurisdiction, and he knew I had him. He knew. That's why he found me guilty and zeroed the fine. So we both walked away winners there. Yeah, we could both say things. So this has been episode 102 of the No State Project, live from the Fortified Compound in Mesa, Arizona. If you want to, I appreciate the support of the show. If you'd like to be able to support the show, you can do so at markstevens.cells.com or just go to markstevens.net. So hey, but till next time, salud.